Welcome to EU Privacy for All, Session 51 on GDPR, Freedom of Expression and Personal Data Processing, Article 80. European Parliament modifications of Article 80 were not as important as European Council one. For instance, EU Council suggested that in the first paragraph, the national law of the Member States would be to reconcile the rights to the protection of personal data pursuant to this regulation with the right to freedom of expression and information. The principle would be set, and the second paragraph would frame the obligation that each member state would provide exemptions and derogations if they are necessary to reconcile the right to the protection of personal data and the freedom of expression and information. The final wording of Article 80 lays down that Member States shall, by law, reconcile the right to the protection of personal data pursuant to this regulation with the right to freedom of expression and information, including processing of personal data for journalistic purposes, but also purposes of academic, artistic, or literary expression. In the second paragraph, as suggested by EU Council, the journalistic purposes or the purpose of academic, artistic, or literary expression shall be framed with exemptions and derogations provided by each member state if necessary. Each member state shall also notify to the Commission the set of provisions adopted. Beyond the key principles set in Article 80, there are three key points to take from Recital 121. First, the exemptions based on the freedom of expression and information will specifically target the audiovisual field, new archives and press libraries, impacting data subject, controller and processor, but also transfers the independence of supervisory authorities and the exercise of the consistency mechanism. Second, in case these exemptions or derogation would differ from a member state to another, the national law of the member state to which the controller is subject should apply. And third, it is necessary to interpret those notions and derogations broadly. Another key provision in Recital 53 on the right to be forgotten and the right of each data subject to have personal data concerning him or her deleted has an exemption and derogation based on the freedom of expression and information. That is to say that the further retention of the data should be lawful where it is necessary for exercising the right of freedom of expression. Recital 3a lays down that the right to the protection of personal data is not an absolute right. It must be considered in relation to its function in society and be balanced with other fundamental rights, notably the one of freedom of expression and information. The principle of proportionality will also be key. Article 17.3 on the right to the deletion and erasure of data reminds us that this is not an absolute right and it could be counterbalanced on the basis of the principle of proportionality for exercising the right of freedom of expression and information. Currently, the directive lays down in Article 9 that Member States shall provide for exemptions and derogations in the frame of journalistic purposes or the purpose of artistic or literary expression, only if they are necessary to reconcile on one side the right to privacy and on the other side the rules governing freedom of expression. What should accountable data controllers and processors get prepared for? First, they should bear in mind that the right to the protection of personal data and the right to freedom of expression and information will be framed and reconciled only by national laws and not at EU level. Therefore, concretely, the processing of personal data for journalistic purposes academic, artistic, or literary expression will potentially be framed differently by each member state. That is to say, once again, that the set of exemptions and derogations to the GDPR might be declined in up to 28 versions. EU Commission will be notified by each member state of those derogations. In the case these exemptions or derogations would differ from a member state to another, the national law of the member state to which the controller is subject should apply. The freedom of expression exemptions should be interpreted broadly. Finally, regarding the exercise of the right to be forgotten, the further retention of the data should be lawful where it is necessary for the right of freedom of expression and information. The key question popping is knowing how the supervisory authorities of all EU member states will reconcile national exemptions and derogations with regard to the freedom of expression in a consistent way across EU, and particularly regarding the right to be forgotten online.